So law enforcement instructor Sonny Slaughter and trial attorney Alexis Rosenberg are both here with me to break this down. What we heard there was the prosecution, the state, basically saying, look, you've given us an alibi that you're driving around, but that's it. You haven't given us any details. And in order for you to call witnesses and to talk about these details, you have to name these individuals. You have to tell us the specifics of where you were going. Now, Sonny, let me ask you, what do you think the judge is going to ultimately decide as far as this alibi is concerned? He did say he's going to give the defense more time to submit information, but ultimately, do you think he's going to let this in?
I don't think the judge is going to let this in unless they have very detailed names and information that law enforcement and the prosecution can corroborate. I think this becomes a fishing expedition and not credible evidence that they are trying to introduce. It is important that we focus on credible information and evidence from both parties. This case is so high profile, we cannot have missteps, and I think the judge is not going to allow it to come in.
You know, Alexis, here's the thing. I think that there's this alibi, but why do you think that the defense is holding on to giving additional information? If they have that additional information now, why not just provide it to everybody and not be precluded, or perhaps be precluded down the line? They could give it now.
So we have a couple different things going on here. Some jurisdictions require a notice of alibi, and this jurisdiction is one of those jurisdictions. And in that alibi, it's supposed to have the details as we just heard. I do think that the judge is going to let it in because they really don't want to have a situation where this goes up on appeal, they get a conviction, and then it's sent back down because they didn't allow the alibi. The defense, I think the problem we have, and what the defense's position is, that he was driving around. I think they've already let out that there weren't necessarily any witnesses to the fact that he was driving around, other than the fact maybe that this was his normal pattern to drive around aimlessly, basically, at night. And so there aren't. Now, why he can't give a general description of where he went, I don't know. It may be a communication thing where the defendant isn't sharing it with his attorneys.
I think you're right. Mm-hmm. It could very well be something that they just don't want to share at this point in time, but it's a very important issue, and you're right, out in Idaho, they do have to have that notice of alibi, and they should be providing additional details. So let's take a quick break right now, and when we come back, we'll have more for you on Law and Crime. So all of that DNA found at the scene is presumably vital information to the case. And Michael, what I'm thinking here is the prosecution wants to protect that information. They don't want the defense to see it. The defense has said, no, we want to see it. We want to know what led to the analysis and how you actually got to Bryan Kohberger. What do you think about that? Should the defense prevail as far as that's concerned?
I think they should. This is a very serious murder case, even if it wasn't a murder case. The defense is entitled to evidence related to scientific evidence related to the crime, related to the crime scene, and it's really not the job of the prosecutor to try to figure out what is information that is either exculpatory, that is under the Brady doctrine that has to go over because it helps the defendant, or not. And even if it doesn't connect the defendant to the crime scene, or if it does connect it, it's up to the defense to figure out how they're going to use that. And to me, if it's part of the testing, part of the DNA process, turn it over. Why even take a chance on a case like this to do something that could result in an appellate issue? It doesn't make any sense to me.
I was actually thinking the exact same thing. Alexis, that DNA was found on the sheath, and that is the most important piece of evidence here. Why not turn over everything? Why not, particularly if, as Michael said, it is exculpatory evidence? You don't want an issue on appeal. What are your thoughts about that?
Well, I agree with you 100%. I think that these motions, because there was a bunch of motions flying on Friday, this motion is a little more complicated than just that, because we have this genealogy which has been used in past cases related to DNA, and that is really kind of the crux of what they're arguing about, because the defense wants the whole process for that. There has been case law where the prosecution hasn't had to turn that over, and sometimes they just allow it and they take it for what it is. But this is very serious, and I think that the defense has a right to know that have everything turned over to them. It is appealable if it's not, and the process so they can contest whether the testing was done appropriately in this situation.
Now, Michael, what happens? Okay, so they turn it over, the testing is done appropriately, but one of the issues I think is, could there be another potential suspect with this DNA? I mean, perhaps there is, and probably that is a good reason to give it to the defense if there's another one who could have been charged with this. What are your thoughts?
Well, that's exactly right. It's up to the defense to try and figure out, to put forward that defense. And one of those defenses very well may be that there was a third party. Obviously, the argument's going to be it was the third party who committed the offense conduct. And they have a right to know that, yes, there's some other unexplained bits of DNA that were found at that location. And look, it's up to the prosecution to argue, well, they had visitors, they had other people who could have been there, et cetera. But it's a fair argument for the defense to be able to make that there is some other unidentified pieces of evidence there, and they should be entitled to make that argument if it's scientifically upheld.
Yeah, and you know, if this case is appealed on this very issue, Alexis, then, you know, we may have missed an opportunity. The prosecution may have missed an opportunity to actually pinpoint, let's say Bryan Kohberger is the individual who committed this crime. And let's say, you know, they don't turn over this evidence. That is something that we really could lose on appeal. You mentioned that you've seen the case decided both ways. Sometimes it's given, sometimes it's not. But because of that appeal issue, don't you think it's important to, you know, turn over that type of evidence?
Well, they're supposed to turn over that evidence. With the genealogy investigatory portion of the DNA, that's fairly new. So that's different than just straight what they were kind of touching on in the clip we heard about lab. So, but they need to turn it over. I mean, this is a high profile case. We have 4 college students that are dead. The prosecution really needs to make sure that they're doing every single thing correct, because this would be a horrible situation for the families to have a conviction and then ultimately it's overturned because they were kind of hiding fault.
Great point, Alexis. Thank you for pointing that out. Let's take a quick break, and when we come back, we'll have more here at Law and Crime.